A party can challenge the validity of a prenuptial agreement. Pursuant to statute, the burden of proof to set aside a premarital agreement is on the party who is claiming the agreement is unenforceable. A premarital agreement may be set aside if the party seeking to render it unenforceable can prove by clear and convincing evidence that the party executed the agreement involuntarily or there was fraud or duress in the execution of the agreement. It can also be set aside if the agreement was unconscionable at the time enforcement is sought or at the time the agreement was entered. An unconscionable agreement is one that either, due to a lack of property or employability, would render a spouse without a means of reasonable support, which would make a spouse a public charge, or which would provide a standard of living far below that which was enjoyed before the marriage. It is important to note that in 2013, the New Jersey legislature amended the statute to remove the language that deemed a prenuptial agreement unenforceable if it was unconscionable at the time enforcement was sought. Therefore, only those premarital agreements executed prior to June 23, 2013 can be set aside on the grounds that the agreement was unconscionable at the time enforcement was sought. A party may also set aside a prenuptial agreement if before execution of the agreement they were not provided full and fair disclosure of the earnings and property of the other party, they did not voluntarily and expressly waive in writing any right to disclosure of the property or financial obligations of the other party beyond the disclosure provided, they did not have or reasonably could not have had an adequate knowledge of the property or financial obligations of the other party, did not consult with independent legal counsel, and did not voluntarily and expressly waive in writing the opportunity to consult with independent legal counsel.